I guess I'll do it. My daddy told me the facts of life when I was Bobby's age, and I turned out okay.
Yeehaw! Hey, what you crying for, boy? It's a good show. This is a damn good show.
Yeah, that's also how he taught me about paying taxes.
Today on Legalese, we are going to be talking about the Supreme Court opinion in the case of Moore v. United States. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is the podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, let me remind you guys real quick here. If you want to find out more about our show, you can go check out our homepage over at legalespodcast.com. And if you want to stay up to date whenever I post new content, because I don't just post videos on YouTube, I do post on alternative platforms. I write articles on Substack. I also post show notes pages over there. And if you want to get notifications for some or all of those things, either way, all you have to do is head on over to legaleshow.com, where you can subscribe to our newsletter, decide what content you want to get notifications about, and it will be sent right to you. All right. So, as I mentioned, we are today going to be talking about the case of Moore v. United States, which is probably the most important tax case you have very likely never heard of. Now, we have been covering this case on this channel here as part of my Supreme Court Roundup, so I have videos covering the cert petition for the case last fall. We covered the oral arguments. I'll be linking to both of those pages on the show notes page for this episode. But before we really dig in here, I have one caveat that I just want to make crystal clear before we get into the particulars of the case, because the vast majority of media coverage about this case, and this has been true both before and after the opinion came out, has been, everyone is referring to this case as a challenge to a wealth tax, which it is absolutely not in any sense. So this is a case about taxing unrealized income. Now, of course, this confusion only got worse now that the court handed down its opinion in the case, and the majority opinion's author, Justice Brett Kavanaugh, decided it was a good idea to talk about the potential role this precedent might play in some hypothetical future case about some hypothetical future wealth tax. But as we will be discussing here today, the only legal question before the court in this case is a challenge to an existing income tax called the MRT, and challenging its constitutionality under the 16th Amendment, which is, of course, the amendment that made armed robbery constitutional. By which I mean, of course, creating the ability to directly tax income sans apportionment.
Daddy, what do taxes pay for?
Oh, why, everything. Policemen, trees, sunshine. And let's not forget the folks who just don't feel like working, God bless them.
So let's go over a little background here. Under Article 1 of the Constitution, as originally ratified, Congress could only levy a direct tax if such taxes were apportioned among the several states, meaning in proportion to their populations. Now, the 16th Amendment was added to provide a limited exception to the apportionment requirement. Under it, Congress shall have the power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. Now, in the 2017 Tax Cuts and Jobs Act passed by the Trump administration, Congress would enact a one-time mandatory repatriation tax, also called the MRT, in an effort to obtain tax revenue from large earnings that corporations held abroad. Now, the MRT classifies U.S. taxpayer-controlled foreign corporations accumulated post-1986 deferred foreign income as part of the corporation's taxable income during 2017. And look, I realize this is really over technical and maybe hard to follow, but this will just take a moment to get through, and I promise you by the end of this video, this will all make perfect sense, so just bear with me here. So anyways, under this MRT, U.S. shareholders owning 10% or more of such a foreign corporation could be required to pay a one-time tax due to their obligations to include in their 2017 gross income their pro rata share of the CFC's relevant income for such year. So essentially what this is a tax that requires 10% shareholders to pay a tax on their share of the corporation's retained earnings, even though that money had not been distributed to them.
We want more money. Yeah, more money.
More money from where?
Just more money, you know. Other countries have lots of money. We want some of that money.
Now, enter Charles and Kathleen Moore, a couple who owned a 13% stake in an Indian corporation formed to supply affordable equipment to small farmers in poor regions of India. Now, this corporation has earned profits every year, but in keeping with its founder's vision, it has always reinvested its earnings into expanding the business instead of distributing dividends to its shareholders. And so in 2018, when the Moores learned that under the 2017 law, they had to pay a one-time tax for their share of the company's lifetime earnings in the amount of $14,729, this completely surprised the Moores, who had never actually received any dividends from the company and lacked the authority to even compel them to pay that dividend. Now, the Moores would pay the tax and sue the government, asserting that the MRT is unconstitutional because it imposes a direct tax that is not apportioned, rather than a permissible income tax. Now, the district court granted the government's motion to dismiss, holding that the MRT is a taxation of income falling within Congress's power under the 16th Amendment. And the U.S. Court of Appeals for the Ninth Circuit would affirm, holding that the Supreme Court has made clear that realization of income is not a constitutional requirement. And the Court of Appeals denied the Moores' petition for panel rehearing, hoping to have the case reheard en banc. And Judge Patrick Bumate dissented from the denial of rehearing en banc in an opinion that was joined by 3 other judges. Now, he would have read a realization requirement into the 16th Amendment. So this is the case that the Moores sought review on from the Supreme Court. And in their petition for cert, what they said was, the Ninth Circuit's decision shatters what had been an unbroken judicial consensus dating back to Eisner v. McComber, that the 16th Amendment's exemption from apportionment is limited to taxes on realized gains. And the Moores note that the issue is directly relevant to the constitutionality of a wealth tax that some in Congress have been advocating in recent years. And so, this last Thursday, the Supreme Court would uphold the MRT provision of the 2017 corporate tax reform law. And by a vote of 7-2, the court ruled that the tax does not violate the Constitution. Justice Brett Kavanaugh would write for the majority, and he was stressing that the court's ruling was a narrow one. Now, Kavanaugh noted that a contrary decision, quote, could render vast swaths of the Internal Revenue Code unconstitutional, end quote. Now, if you think it is absurd that a judge could, in the same breath, insist that this decision of the court is a very narrow decision before going on to give an opinion about how this case could be applied to just about every provision of the entire federal fucking tax code being an just unbelievably asinine and contradictory statement, well, you're not alone. That was my first impression too in reading the case, and as we will be getting to a little later on in this video, Justice Thomas and Justice Gorsuch felt the same way. And they make a devastatingly strong criticism of this aspect of the majority opinion. And in its 24-page ruling, the majority did not resolve the question whether, as the Moores contended and the government disputed, the Constitution requires income to be realized before it can be taxed, which was the entire fucking point of the case. Instead, Kavanaugh explained the real, precise, and narrow question before the justices was whether Congress can attribute income that an entity has realized but not distributed to its shareholders or partners, and then tax that income. So for Kavanaugh and the 4 other justices who joined his majority opinion, which were Chief Justice Roberts, Justice Sonia Sotomayor, Justice Elena Kagan, and Justice Ketanji Brown Jackson, the answer was clear from the Supreme Court's long-standing precedents: yes. Although they did stress that their ruling was a narrow one that applies when Congress treats the entity as a pass-through. Now, moreover, Kavanaugh would continue in his opinion, in an effort to contain the blast radius of their legal theory, the Moores have concluded that other taxes such as partnership taxes, taxes on S corporations, and taxes under Subpart F of the Internal Revenue Code, which applies to American-controlled foreign corporations, are constitutional. He goes on, because the Moores cannot meaningfully distinguish the mandatory repatriation tax from those other taxes, Kavanaugh's reasoning was that their argument, taken to its logical conclusion, would mean that other parts of the code are also unconstitutional, which could in turn cost the federal government trillions in lost revenue. But this claim is just facially untrue. The Moores did distinguish between the MRT and the other taxes that they do concede are constitutional, in that the MRT forces them to pay taxes on unrealized income. That was the entire point of the case, and that was a point the judges just completely looked over. So bear in mind, they are being taxed on money they do not have. It's money they would have if they sold their shares in the foreign corporation that they have that ownership stake in. Now, Kavanaugh would go on to say, the logical implication of the Moores theory would therefore require Congress to either drastically cut critical national programs or significantly increase taxes on remaining sources available to it, including, of course, on ordinary Americans. The Constitution, Kavanaugh concluded, does not require that fiscal calamity.
What are you basing that on, Mom? Who wants ginger snaps?
And that statement is just shamefully ridiculous. First of all, what makes something constitutional has nothing to do with whether some judge believes the law constitutes unwise fiscal policy. Besides, this is a one-time tax that didn't exist until 2017. If you want to know how to fund the government without relying on a tax passed in 2017, all you have to do is ask how the government managed to act without fiscal calamity in 2016. And every single fucking year before that, for more than a century, going all the way back to the passage of the 16th Amendment that made theft constitutional back in 1913. Now, while Justice Jackson joined the Kavanaugh opinion, she also penned a brief concurring opinion in which she contended that the court's role in tax disputes should be a limited one. She wrote, "I have no doubt that future Congresses will pass and future presidents will sign taxes that outrage one group or another, but the court's tax cases demonstrate the remedy for such abuses is to be found at the ballot box.
Really, Amy? Because I've met some people, okay, real people, and I got to tell you, a lot of them are fucking idiots.
Now, on the other hand, two justices who would vote to uphold the law, but who wrote concurring opinions and did not even join Brett Kavanaugh's opinion, were Justice Amy Coney Barrett and Samuel Alito. And in an opinion written by Barrett, joined by Alito, they would agree with the court's decision to uphold the lower court's ruling in favor of the government, but not with her colleague's reasoning. In her view, quote, Congress's power to attribute the income of closely held corporations to their shareholders is a difficult question, and unfortunately, the parties barely addressed it, end quote. But she says because the Moores have conceded that subpart F is constitutional, and that section of the Internal Revenue Code is not meaningfully different from the MRT in how it attributes corporate income to shareholders, she would conclude, the Moores have simply not met their burden to show that they are entitled to a refund. And of course, as usual, the voices of clarity among a 7-2 split were Justices Clarence Thomas and Neil Gorsuch, who gave this law and the 16th Amendment its only logical meaning. In the opinion that was written by Justice Thomas and joined by Justice Neil Gorsuch, the minority would argue that, for the purposes of the 16th Amendment, income is only income that a taxpayer receives. And because the Moores never actually received any of their investment gains, those unrealized gains could not be taxed as income. Now, Thomas would go on to be sharply critical of what he fairly brilliantly characterized as the consequentialist heart of the majority's opinion. Now, Thomas agreed with Kavanaugh that the Constitution does not mandate the fiscal calamity of requiring Congress to cut programs or increase taxes. But in his opinion, he says, quote, if Congress invites calamity by building the tax base on constitutional quicksand, the judicial power afforded to this court does not include the power to fashion an emergency escape.
So, people are really used to this flavor. And you know what else they're used to? They're used to taking it in the ass. As in, they pay taxes and they get that water and they do nothing about it. They might scream a little bit and say, oh, our water's bad, but they end up not doing very much, so it doesn't really matter. So I like to emulate that sort of, that sentiment of paying taxes, paying really high taxes and getting nothing in return, not even clean water.
Now, Thomas would also strike a devastating blow to the absurdity and the contradictory nature of the majority's opinion. So he said, even as the majority admits to reasoning from fiscal consequences, it apparently believes that a generous application of dicta will guard against unconstitutional taxes in the future. And he's talking about things such as a wealth tax. But, Thomas would caution, if the court is not willing to uphold limitations on the taxing power in expensive cases, cheap dicta will make no difference. Now, for those of you who may be unfamiliar with the term dicta, we've talked about this here on the show before, but it's been a while, so let's just quickly revisit that. So, dicta is short for the Latin phrase obiter dictum, which means something said in passing, and when it is used in law, the phrase dicta refers to a comment, suggestion, or observation made by a judge in an opinion that is not necessary to resolve the case, and as such is not legally binding on other courts. But Justice Thomas's blistering criticism does not stop there. He goes on to say, the majority's analysis begins with a list of non-existent taxes that the court does not today bless, including a wealth tax. And it concludes by offering a narrow interpretation of its own holding, hinting at limiting doctrines, prejudicing future taxes, cataloging the government's concessions, and reserving other questions for another day. Sensing that upholding the MRT sees additional ground to Congress, the majority arms itself with dicta to tell Congress no in the future. Now, if I can go off on a bit of a tangent here, if anyone has ever wondered why I sometimes mention offhand that I don't much care for Justice Kavanaugh, read this majority opinion and you will begin to understand. There are two things that he loves to do in his opinion. One is to include quotes from the transcript of the oral arguments that have been made in a case, but not just any part of the oral arguments. It's usually when he or sometimes one of his colleagues will ask the Solicitor General a question that they have great difficulty in answering, which he also did in this case. Now, I realize this may sound like a harmless or obnoxious habit, but where it becomes problematic is that if the court is citing the transcript of an oral argument, the concession being made does not appear anywhere in the brief. If it's not in the brief, it's not an issue the court is even being asked to take judicial notice of, and it has no business in a final opinion. Now, the other hallmark of a Justice Kavanaugh opinion that bothers me is his proclivity for answering questions that no one fucking asked. Now, the reason I usually don't point this out is because Kavanaugh usually only does these things in his concurring opinions, where the opinion of sometimes one judge, but usually two, as he and Chief Justice John Roberts are really a hive mind that think exactly alike. But either way, in his concurring opinions of one or two judges, they have virtually no impact on how the lower courts may apply his irrelevant opinions, such as his concurrence in the Dobbs opinion, where he felt the urge to not only decide the issue of abortion before the court, but he also felt compelled to decide the question on the right to travel. Or in the Bruin case, where he didn't just decide on the matter of a May issue permitting scheme as existed in New York, he also felt he was entitled to decide on the question of mental health background checks. And where this proclivity goes from useless to potentially harmful is when he is writing the majority opinion for the court. And so Josh Blackman, constitutional scholar, would point out in an article that he wrote about this case called "With the Constitution Deciding Less is More," he says, in Moore, Kavanaugh was assigned one of his most significant majority opinions, and he brought his faux minimalism to the whole court. The bottom line vote is 7-2, but Justice Barrett's concurrence, joined by Justice Alito, is much closer to Justice Thomas than to the majority. In reality, this is yet another 5-4 case where Chief Justice Roberts and Justice Kavanaugh simply join the court's progressives. And this is exactly what Justice Thomas was rightfully criticizing in his dissent. Why would the court not want to declare a trivial tax unconstitutional, while at the same time reaching a decision on an issue such as the wealth tax to preemptively try to stop it from potentially going forward? There is no good reason for the court to answer questions that are not before them. But anyways, that is really all I got for you guys here today on Legalese. Thank you so much for tuning in. Now, stay tuned because we've got more videos to come. I still have to do my Supreme Court wrap-up video on U.S. v. Rahimi, and we still got a bunch more opinions that'll be coming next week in some of the most important cases, like Jarchese, Loper Bright. So you definitely want to make sure you're subscribed to the channel so you get notifications as these important opinions come out. Now, furthermore, if you would please take a moment and do all of those things for me that help to trigger Al Gore's rhythm, I would greatly appreciate it. If you liked the video, hit that like button. If you disliked it, you can hit the dislike button if you want. Leave me a comment. Let me know what you thought about either this video or the topic we discussed or just anything you want to. I do really enjoy getting a chance to hear your guys' comments on these videos and interact with you as much as I can in the comment section. So if you would do those things for me, I would be most grateful. And until next time, this has been Bob for Legalese, talking about more v United States. And of course, as always, Carthago delenda est.
Motherfucker, like Freddie Mercury. Motherfucker. I got a trunk full of amps, motherfucker. I got a trunk full of amps, motherfucker. I got a trunk full of amps, motherfucker.